Here we are with record-keeping requirements, surely a great favorite of all of you web learners. My name is Mark Honig. I'm a partner at Weil, Gotshal & Manges. I wear a number of hats here. One of them is as co-chair of the not-for-profit practice group. And we're going to be talking today about record-keeping requirements. Before we launch into this, well, I guess I could first say who I'm doing this with, if I could figure out how to, here we go, whoops, no? All right, try that again. Perfect. Weil Gotshal is providing this in partnership with Pro Bono Partnership, as well as Pro Bono Partnership Atlanta and the DC Bar Pro Bono program. Before we really get started, I really wanted to give you a setting here. I spoke with my wife earlier today. She runs her own interior design business. I said I would be talking about record keeping. She sort of chuckled to herself. She says, like, really? Is that going to take more than 2 minutes? And I guess my answer to her is, we'll see. I suppose as I think about it, there are probably 3 elements to record keeping, which are all interrelated and probably all self-evident. One is just basically the need to appreciate that you need to keep a record, make a record. And we'll get a little bit more into that in a bit. The other is the idea that you need to hold on to it for some period of time, depending on the whole reason why you have made the record. It's going to, of course, inform the length of time that you will want to hold on to it, retain it. And finally, the other element which sort of puts those things together is a so-called policy, a record retention policy, which is of course something an organization will want to do to create guidelines around when to make records, how to make records, and most importantly, how long to keep them, and probably also when to discard or destroy them. So this first slide, board should adopt a record retention policy, in some measure is sort of the punchline. We will finally get to the record retention policy, but we first want to lead into it and figure out why. To do that, I was going to offer 3 or so scenarios just to create a context. Excuse me. So let's imagine you are either a board member or the executive director or senior staff in your organization, and you confront any of the following. You're threatened with a lawsuit for age discrimination. Another scenario is you are negotiating and formulating compensation arrangements with a senior executive or executive director. The next one is you are undergoing financial stress and you need to try and figure out what you should be doing about it, what can you be doing about it. And the last one is something that's commonly referred to as mission creep. You're sitting around appreciating that either you are doing something that's not necessarily part of your original mission or you'd like to. The common denominator, won't surprise anybody, to those 4 scenarios is that in order to properly deal with any of that, you need to have properly maintained and properly retained records. So let's talk about the sources of where the cause is for you to want to worry about record retention. We'll start with the IRS. It probably bears noting that so-called IRS provisions, the tax law provisions, apply to organizations that are exempt from taxes. That may or may not be the same as all nonprofits. Many or most nonprofits are also tax exempt, but when we talk now about tax requirements, IRS provisions, these are requirements that apply to tax exempt organizations under the federal tax law. And analogous rules, by the way, may or may not be found under state tax laws. Under the IRS, records must clearly show income and expenses. That will surprise hopefully none of you that when an organization, a quote taxpayer or even a non-taxpayer is charged with reporting taxes on tax story over the course of a period of time, a year, a 12-month period, the law requires that they have a clear record of their incomes, expenses, of course, and other elements that go into the makeup of their tax return. As anybody who's watching this presumably knows, there's a Form 990 that is the annual tax return filed by tax-exempt organizations. There was something of a hubbub about 5-6 years ago when the IRS substantially revamped the Form 990. The hubbub was because, as I'll mention in a moment, the form now asks a lot of questions that don't seem to have anything to do with exemption, exempt status, and qualification for exempt status. It has a lot to do with elements of governance. The IRS explained at the time that they think good governance is critical to compliance with law, and that if they are asking these questions and they get answers suggestive of not good governance, the IRS says they will look much more critically and skeptically at the organization and its tax return. So that's as a result of that, or nonprofit / tax exempt organizations are very much inclined to fill out the tax return, the Form 990, in a way that, in effect, gives the IRS the answers that they're looking for, so that they don't incur additional scrutiny. Among the things the Form 990 does ask for is whether you contemporaneously document your board and committee meetings, as well as whether you have a written document retention and destruction policy. As I mentioned, these are the kinds of questions that organizations like to be able to, of course, honestly answer yes. Other things that are under the tax law that I think also are relevant, perhaps subsidiary to those things, are the tax law now over the last about 10 years, contains provisions referred to as excess benefit transactions or intermediate sanctions that are applicable, that apply penalties to not only to the organization, but possibly even to decision makers such as board members in situations where the organization in effect overpays for services or for goods. It very often, for example, comes up in issues where are you overpaying compensation to a chief executive, for example. The reason it's relevant to record keeping is that there is a safe harbor in the tax law that basically requires a number of components in order to create a presumption that you are not in violation of these rules. And one of those is a committee made up of independent people who do certain things, and this is the big end, who keep contemporaneous minutes of that committee meeting. We'll talk a little bit more about minutes in a few slides, but the point here is that there are, at least in this case, there's a tax law element that pushes an organization to have to keep and to retain contemporaneous committee meeting minutes. I'll say one other thing, which is perhaps a footnote. This is not a New York-centric conversation, but different states have different rules. But by way of example, New York State recently enacted legislation, the Nonprofit Revitalization Act, earlier this summer, still waiting to be signed by the governor, but expected to be so, that actually makes a requirement for related party transactions comparable, not exactly the same, but comparable to the IRS safe harbor. So here's an example of a state law that actually requires the keeping of minutes. I think that's part of a bigger observation that anything we talk about as relates to an organization should do this, it's better practice to do this, it's best practices to do this, as a expectation. I think one should appreciate that best practices become rules sooner or later. So the wise person appreciates that. Lastly, I'll say before we move to the next slide about the tax law record keeping has to do, I think, with acknowledgments. There's really two kinds of acknowledgments for donor donations that a charity is either compelled to or should issue. The more common one, I suppose, is the simple acknowledgement, which says thank you very much for your contribution. The rules that underline that are that if you give $250 or more donation to a charity, the IRS requires, and this is a requirement imposed on the donor, substantiation in the form of a letter from the charity. Interestingly, that is not an obligation imposed on the charity. However, any charity that hopes to get donations obviously needs to comply with this set of rules and help their donor to substantiate and support the tax position they're taking on their tax return. That's one kind of acknowledgement. That's a fairly common one. Obviously, the charity will need records in order to make those substantiation, those acknowledgments. The second piece of paper that relates to donor contributions is actually, yes, an obligation imposed on charities, and that's the so-called quid pro quo acknowledgement, and that applies whenever a charity gets more than $75 in exchange, partly for stuff, goods or services, and partly as a donation. So, for example, commonly that would be in the setting of an auction, where a charity might sell an item that's worth $10 and get $20. That's of course, if you put an extra zero on it, it will exceed $75, and that's a situation where a charity is obliged by law to issue a so-called quid pro quo acknowledgement. Again, another tax law reason for charities to concern themselves with maintenance of records. Then, of course, there are the federal government, the federal tax government requirements of disclosure of certain records. Essentially, under the tax law, every charity is obliged to make available for public inspection at two things: the Form 1023 and everything associated, frankly, with the application for tax exemption, and so that's something that has to be made available through the life of the organization. And then there's the tax returns, the Form 990 and other tax returns that the organization is obliged to make available for public inspection for a 3-year period following the filing of the return. So, of course, with those obligations, the organization has yet further additional reasons to be sure that they are keeping and maintaining the right sets of documents. To sort of talk a little bit about that, I guess because this becomes interesting to some people, the tax law requirement for public inspection indicates that if somebody just walks in off of the street and says, "I'd like to see either of these two items," you are actually obliged to show them right away that day. That's if you have a principal office. If you don't have a principal office, then I think you get 2 weeks. If they call you, there's a different rule. Please mail it to me. You have 30 days. You can charge reasonable amounts for expenses incurred. There are some actually relaxation of these rules if you post your forms properly on your website or on a website, as long as it's in the right format. And these are rules that I will not be talking in detail right now, but good to know. One thing that people do get confused about, however, is if you post on your website, that does not absolve you of the obligation to show your important documents to people if they walk in off the street. One other exception perhaps is worth noting in this context, which is the obligation imposed under the tax law to disclose these important documents. There's an exception if you can establish that you're being harassed, and that's, to some organizations, an important exception. And the last thing I think I'll say about this is that there are some special rules that allow the organization not to disclose sensitive information, such as trade secrets, the names of donors, social security numbers of insiders, and the like. There are other legal requirements as well. in addition to the ones that I've just noted. These legal requirements come under also to some extent under the tax laws, state law, other federal law. The records in connection with litigation or potential legal action have to be kept until the resolution of those matters. As I mentioned, there's the federal tax requirements. I think we talked about maintenance of books and records on a tax year basis. We talked about that. I'll just note that's not a how long you have to keep something. That's a how you have to keep something. The books and records need to be maintained in a certain way. You're obliged to keep your financial records and your supporting documentation as relates to your tax returns until the applicable statute is over. Statute of limitations generally for tax returns is 3 years, although it can be extended in certain cases. I think smart people will hold on to this information until at least 6 years and perhaps even 7 years. And as I mentioned, as I mentioned before, there's obligation to share the Forms 990 for 3 years, although because of what we just said, it makes a lot of sense to hold on to the Forms 990 at least for 6 and maybe 7 years. There also are, if I could figure out how to do this, there also are, as I said, state and local requirements, which they vary from state to state. Check your state law. There are some states, and the example on the slide is California, with a 10-year statute, which would require you to keep the relevant information longer than in other states, and you need to be cognizant of where you are subject, which state subjects you to these types of maintenance, record maintenance obligations. If you are a membership organization, and what that means is that under the state law under which you are formed, you have members, and that's a statutory member. It's distinguished from other types of members and organizations that are not statutory, such as members in the bar association, members of your local library, that kind of thing. Now, these are statutory members, and very often state law will impose on an organization the obligation to maintain records and make them available to the members of the organization. And as well, board members have a right to inspect records. That's actually an interesting thing to some people who, particularly to certain organizations where I find it in schools, for example, where the idea is that the board is not really there to do anything but to go and spread goodwill and cheer to the community at large. There's a lack of an appreciation that the board is really there to oversee the organization, and not surprisingly, therefore, has an absolute right to inspect the records, which of course informs the obligation and the need for the organization to maintain and retain good records. There are charitable solicitation rules in frankly every state. Many of them require the nonprofit to keep certain types of information available. And then there's the last part of this particular slide, federal employment laws. There's actually a panoply of federal employment laws that require organizations to maintain information about personnel hiring, personnel evaluation, employment, just about every element of the employee-employer relationship. So you need to really be cognizant of that as well. And I'll mention before we move on, Sarbanes-Oxley, which I think it was pretty old by now. There are two, mostly it deals with public companies, but at least two elements of it deal and relate to nonprofits. Under Sarbanes-Oxley, nonprofits need to have a whistleblower policy, and as well are subject to the document retention rules. Specifically, it's a crime under Sarbanes-Oxley to destroy documents that are relevant in the context of a federal government investigation, where your intent is to obstruct the investigation. So yet another reason to focus on document retention. So here we are. We're going to introduce the concept of a record retention policy. Now that hopefully we have an idea of all the reasons you'll want to indeed focus on retaining the right documents and the right thing. Essentially, just to distill what we already said, uh, proper maintenance, retention, and frankly, discarding of the right types of documents is important to protect your organization against, in the context of litigation. It's important, of course, to follow law. We talked about the tax law, we talked about the federal employment law, we talked about a few other laws. And of course, and this is probably the overriding thing, it's important to achieve mission. It shouldn't actually be need to be said that to actually run a business, whether it's in this case a charitable business, the failure to focus on the organization's records and knowing the organizational history, where you came from, what agreements you have made, what agreements you haven't made, what your relationships are with your employees, et cetera, et cetera, et cetera. The idea that you can properly run a business without doing that properly is frankly silly. The other half of the equation, by the way, I've alluded to it once or twice, is the right documents should be discarded or destroyed. There are a few reasons to discard and destroy. One is that to save unnecessary or unimportant documents is probably a waste of money. Another thing to consider is that when you do try to find important documents, the fact that you have a lot of junk included in your files or wherever is probably going to waste your time, again, as you try and find important things. And I guess the last thing I'll say, and hopefully I won't be misunderstood, is there are sometimes that you are not obliged to retain something that's not a proper reflection of either what the organization has done, what it's decided, what it considered, and it just should be discarded because it would be, if you will, bad evidence suggesting the wrong thing at the wrong time. But of course, you've got to comply with federal and other rules that do not allow you to discard things at certain times. How do you create a policy, a record retention policy? It's kind of simple, although it probably is time-consuming, but principally simple. You should get a handle on all of the documents in your organization, frankly, and that's, as I said, simply said, but not simply done. Sort through by importance of those documents, and then create probably guidelines around different levels of importance. Things that you decide are not really important, you should indicate should be discarded either right away or over a quick or short period of time. Some things will be proper to keep for some kind of a mid-level period, perhaps 2, perhaps 3, perhaps 4 years. Some things longer term, and some things, frankly, many things, frankly, permanently. Here we have a listing of things that ideally should be kept permanently. As we said, the Form 1023 application for tax exempt status, frankly, you have to. I'll relate that back to one of the scenarios I introduced this with. If you start to talk about mission creep, and somebody smart says, "Can we do that? Do we need to get anybody's permission? Is that going to be a problem?" When people ask me that question, I say, "Well, let me see your charter. Let me see your application for tax exempt status for two things." And the reason I say that is because the charter defines the mission, and it defines the type of thing you can do and maintain the state's recognition of you as a properly functioning entity. And your Form 1023, your tax exemption, your application for tax exemption, is essentially a document that represents to the IRS everything you're about, everything you're going to do, and on that basis, the IRS presumably has given you its determination that indeed you're tax exempt. So one must look at that document as something you are bound to. If you breach what you've said to the IRS inside of that document, you really do risk that the determination letter, in fact, the thing you got in return for those representations, the determination of exempt status from the IRS, may not be as valid as you would like. So that's just an example of, and I must say how often people say, well, gee, we don't have that's a long time ago, or my goodness, how are we going to find such a thing? To me, the application for exempt status is probably almost, if not as important as the very certificate of incorporation of the organization, which defines the mission. Other very important letters, not surprisingly, the IRS determination letter, and that I mentioned, that's the letter by which the IRS grants exempt status. Very often donors or others will want to see that, and it's fairly embarrassing, frankly, not to be able to provide a copy of the letter that actually says you are tax exempt. Articles and bylaws, committee minutes, policies, resolutions. A word about committee minutes and board minutes. Many organizations, I think, don't understand the goal, the objective of board and committee minutes, and therefore don't understand how both to keep them and why to retain them. To take a board minutes. Board minutes are important essentially for two obvious reasons, I hope. One is it is a blueprint, a history. This is what was decided. This is what this organization does. It is the history of the corporate action from meeting to meeting from time to time. Without that, you cannot go back and understand where you came from, where you're supposed to be going as an organization. The other element is it's important to substantiate certain things, to protect against certain legal liability. For example, an organization that has a big mortgage and the board has just never discussed how it's going to make payments, and then of course it goes into default. That's one organization. Another organization where the board actually had very robust conversations and made some decisions, even though those decisions didn't turn out to be right, but they were valid and reasonable. I would rather be on that second organization, and I'd rather have minutes that reflected there was a robust conversation about that, again, as opposed to the organization that has had no discussion or even does not have the minutes to support the fact that there was that discussion. So with that in mind, I call attention to the fact that minutes, and I mentioned earlier, I think a school organization, minutes shouldn't be talking a lot about, and the principal said that the kids had a great deal of fun when they went on their trip. I don't really think of that as the important part of board work. So the point again is understand the role of the board, understand the role of the committee, and the minutes should reflect that role and those obligations, frankly, have been properly discharged. Anyway, this slide contains a number of other important things that probably should be kept for a long period of time, if not permanently. Other records, and these probably fall into some of the less important things, but not unimportant. Records about donors and the things that donors have given, haven't given. Records about donors, for frankly, if they have or have not imposed any kind of a restriction on the donation. Those are things that you want to want to carry out, and therefore have to know, and see if it ever comes back to you where a donor says, yeah, but I said this or you said that. You would like to have a contemporaneous documentation of indeed what was and was not said. As I said, minute books are terribly important and should be prepared contemporaneously so as not to be subject to skepticism. It's not the last slide, sorry. This slide talks a lot about minutes and what they should include. I've already earlier mentioned what the importance of minutes are, and therefore I think none of this should come as a surprise. Of course, the name of the organization, date, time, and place of meeting, and who was there, those are very important. Motions made, meaning corporate action made. Just to give the example, you don't make a motion to decide whether the kids had fun at their outing, but there are motions made, and those are the important actions of the organizations. Directors may ask that the minutes state specifically that they voted in a certain way, and that is coincident with what I mentioned earlier, which is these minutes serve as a record of what what the board discussed and the types of give and take there were, again, which will support boards and board members in the context of litigation or attack at a later date. We mentioned, I think already, that there are state and local reporting requirements. These are some things. These are again some presumably some pretty obvious things that you should keep probably for a long time, if not permanently. Your state exemption, tax exemption filings, which is really the analog to the federal, the IRS tax exemption file. There are biannual reports required in states. I think it's fair to say that any kind of filing required, either state or locally, is something that you should keep a copy of for a long time or permanently. Your license, of course, seems to be extremely important and something you would want to maintain, as well the charitable solicitation registration, which is yet another state law obligation to file. You'll want to be sure to keep that. Other common things, contracts. This goes back to an example about, well, we agreed to this, and years later there's a disagreement as to what you agreed to. Well, of course, that's a reason to have written agreements and not oral agreements. Their written agreements are less susceptible to those kinds of disputes. And of course, the length of time you should keep a contract has to coincide with the length of time that you're going to need to know what the terms were, which has to do with the duration of the contract, and then the statute of limitations generally on a contract varies from state to state. But for example, in New York, the duration of the statute for contracts is 6 years. So that gives you a sense of how long you should keep contracts. Bank records, again, there's some debate about whether this slide suggests 7 years. There's some debate whether it might be even longer. Employment records, as I mentioned, this is really the kind of thing where you need to consult your state and federal law, having, as it relates specifically to you, your size, and what type of employees you have. But this is an area where, not surprisingly, you'll find you should err on the side of saving the records. I mentioned earlier the idea of an age discrimination lawsuit, for example, but the examples are myriad. You want to be in a position to defend against, for example, that type of a lawsuit, and the only way to do it is keep, and maintain written records of what you've been doing on that front. The last thing I want to talk about, employee insurance records, HIPAA, and there's a whole set of obligations on the extent to which you have to maintain and frankly keep secret those kinds of records. But I'd like to talk about other forms of correspondence a little bit before I close. Hard copies of internal memoranda, routine matters. The point of this is that internal memoranda perform the same functions as everything else I've been talking about. So they might be an important indicator of the background and history of a decision, which will inform the implementation and the future of that decision. They might not really be important at all. They might be an important indication of what was said to whom. And therefore be an important element of a litigation or a dispute resolution. You've got to look at that sort of thing, but the first thing you need to do organizationally is understand that all those forms of communication can be very important. And I think we all know of organizations where there's something of a casual approach to electronic communications. That is frankly, pretty much a recipe for, I don't want to say disaster, but for some degree of failure. Um, emails, emails in particular, um, again, there's a tendency for us to treat emails even more casually. If you decide to destroy electronic communication and email, I think you need to understand that destroying that type of data, as many people have learned with great pain, is not as simple as hitting a delete button. I'm not a tech wizard by any stretch of the imagination, but you'll want to be sure to look into that if you're interested in eliminating electronic communications. Other forms of non-written records might be voicemails. Oftentimes, a voicemail is very important to an organization. As an organization, you should be cognizant of that, perhaps, and get it into a policy where your senior staff as well as your rank and file staff appreciates that they need to think about whether a particular voicemail has a degree of importance where there should be some form of memorialization, and by the same token, even non voicemail, but something that was merely oral. I had a phone call with, I met with, and we talked about. Very often, those are terribly important as well. Sometimes they're unimportant; they're not important at all. But there needs to be a sensitivity to the possibility that those are very important, and they need to be somehow memorialized. One example might be to ask your staff to create, if you will, a file memorandum detailing the nature of a conversation. Again, a contemporaneous record of what you've done and the length of time during which that should be retained has to do with the function of that record. And with that, I say thank you very much.